We are excited to offer probate services for families in Purcell, Oklahoma. A majority of probates are administered in a long form and they take several months and sometimes even years. For lack of a better word, I call these regular probate proceedings. The attorneys will first determine if there is a last will and testament or no last will and testament. If your loved one died without a last will and testament, this is called dying intestate. The lawyer will draft an initial petition for probate, just like in a summary that I talked about in the last video. If the client agrees with the writing, then the law firm will have the client sign the petition and will file that petition for probate with the court clerk. The judge will order that the petition be heard at some future date, usually 30 days into the future. Probate lawyers will publish notice of this hearing in the local newspaper, and they will also mail a copy of the notice of that hearing to all interested parties. This is usually done by certified mail so that we can prove that they actually received it and that we tried to mail it. At that initial hearing, the court will make 4 determinations. The first one, does the court have jurisdiction to hear the probate? If your loved one did not live in the county or have property in the county, then the court probably does not have jurisdiction. If your loved one did live in the county and had a house there, then the court probably does have jurisdiction. Number 2, is there a valid last will and testament and should it be admitted into the probate? Number 3, should the person who's filing the petition be named as the personal representative? The personal representative is usually the person who has hired the attorneys. Number 4, who are the legal heirs to the estate? The judge will issue an order at that first hearing stating who the legal heirs are. This is important because these legal heirs now have the legal authority to consent to the sale of real estate belonging to the estate. It is also helpful to know whether, the estate is going to be divided up 4 ways or 3 ways. Once the court has made those 4 determinations, it will usually appoint the petitioner as the personal representative. A personal representative is sometimes called an executor, just depending on where you live. This personal representative is charged with administering the estate of the decedent. This involves gathering and identifying all assets, settling claims, administering the estate, and finally distributing what is left over to the heirs. Depending on the state that you live in, creditors usually have 60 days from the filing of a notice to creditors to file a claim against the estate. The notice to creditors is published in a local newspaper in the county where the probate is being administered. Notice to creditors is also mailed to all known creditors of your loved one by certified mail. If a creditor files a claim against the estate, then the personal representative decides if it's a valid claim and whether it should be paid. That claim then must be approved by the judge before any payment can actually be made. Next is a general inventory listing out what's in the estate. This list usually includes what is in the estate, such as personal property, mineral interests, real estate, and financial accounts. When real estate or personal property needs to be sold to satisfy debts or just to make money available for distribution to the heirs, the personal representative will make an application to the court for authority to sell real estate and personal property. Again, the judge must approve it. Now, earlier I stated that the court determined who the legal heirs are of the estate at that initial first hearing. Because the judge has made that determination, all the beneficiaries have the legal authority to consent to the sale of real estate or personal items by the personal representative. They have to give the personal representative permission to sell. If they do, then the executor usually sells the house with a realtor and deposits the proceeds from that sale into the estate bank account. This is a separate estate bank account, not the bank account your loved one had during their lifetime. Once the personal representative has gathered all the assets, paid and settled all the claims, then and only then is the estate ready for closing. This is usually done by a final account filed with the court. Notice of hearing that final account is published in the newspaper, mailed to all interested parties by certified mail, and usually set at some future date, like 30 days into the future. So if you can see, if you've been counting and everything goes perfect, it's usually 4 to 5 months for a probate. They never go perfect, and they usually last 5 to 7 months. If the family starts fighting, then I guarantee it's going to take years. We have had that happen on a regular basis where the family just can't get along, and it takes years because it's hard to get on the court's calendar for hearings and motions and all those things that happen when people start fighting. So the key to getting a probate done is for everybody to get along. I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.